Attorney for the District of Nevada. Thank you so much for taking time out of your day to join us. We're grateful that you're here today because this case is very important to our office. Because there are so many potential victims in this case, we're not always able to respond individually to everyone who reaches out to us. I'd like to thank our dedicated victim witness team for going above and beyond to be as responsive as possible. This virtual town hall is an opportunity to communicate with many of you at the same time. We're glad to provide answers to many of the common questions we've received. To do that, we have here with us Tony Lopez, who is the chief of our office's white-collar crime section. Tony will start with an overview of the criminal case, United States v. Jeffrey Torino, that was prosecuted here in the District of Nevada. Next, Tony will explain the role that our office plays in the restitution process for criminal cases, like who's eligible for restitution and what does the U.S. Attorney's Office file with the court, before Tony addresses frequently asked questions. Thanks again, everyone, for joining us today, and now I'll turn it over to Tony.
Thank you, Chris. And thank you to everyone joining us at today's virtual town hall. Over 1,000 people registered for today's town hall. So as you can imagine, we are unable to allow viewers to ask questions directly because of the volume of participants here today. But we have received numerous questions from potential victims over the past year or so. And my goal today is to help everyone better understand the case and how the restitution process plays out. If you have additional questions, we plan to host another town hall at the end of April to update everyone on the progress. As our U.S. Attorney mentioned, I'll start with an overview of the criminal case, because who may seek restitution depends on the allegations in the criminal case. The case we're talking about is United States versus Jeffrey Torino et al., case number 2:09-CR-132 here in the District of Nevada. In that case, 10 defendants are charged with conspiracy to commit securities fraud and other related crimes. These charges are based on their involvement with numerous corporate shells: CMKM Diamonds, Pinnacle Business Management, St. George Metals, U.S. Canadian Minerals, Biotech Medics, Global Diamond Exchange, Equitable Mining Corporation, OMDA Oil and Gas, Inc., Grand Entertainment and Music. CMKM involved the largest volume. So for purposes of this presentation, I'm going to generally be referring to that entity. But at this time, I want to answer one common question that our office often receives. Are only CMKM stockholders potential victims in this case? And the answer is no. Anyone who purchased stock during the relevant time period for any of these companies could potentially be a victim. The charges in this case are laid out in detail in an 87-page document called the Second Superseding Indictment. That document is available on the CMKM webpage on the U.S. Attorney's Office website so that you can read a detailed description of the case. Though I will try my best today to give you a summary of that 87 pages. The core of the charged fraud is that CMKM insiders fraudulently induced investors to buy shares by issuing false press releases and concealing the fact that they were authorizing new shares. The false press releases and other promotions increased demand for the stock. When demand goes up, price goes up as well. But these insiders were secretly authorizing additional shares. They profited by issuing those shares to nominees, basically straw purchasers, someone they could trust to sell the stock on behalf of the insiders and give the insiders the proceeds from that sale while keeping a portion for themselves. As we'll discuss a little later, the scope of these allegations are important to determining who may seek restitution, because restitution requests must be caused by the criminal offense. And this fraud I just described is the criminal offense in this case. Which brings me to another common topic in questions from potential victims: naked short selling. Now, the indictment alleges that CMKM started rumors of naked short selling to conceal the fact that CMKM insiders had flooded the market with hundreds of billions of unregistered shares. And I understand that some shareholders believe that naked short selling actually occurred. Even if that were true, the criminal case this criminal case is not about naked short selling. No defendant is accused of illegally engaging in naked short selling. So even if naked short selling caused harm to CMKM investors, the criminal case cannot address that. So now that we've clarified what the criminal case is about, where does it stand? As I mentioned before, the case charged 10 defendants, and as the indictment alleges, 3 of those defendants were the leaders of the conspiracy: Jeffrey Torino, John Edwards, and Urban Casavan. All 3 of those defendants have passed away, and only Torino was convicted before his death. This is notable because the court cannot order a defendant who passes away before they are sentenced to pay restitution. While Mr. Torino was ordered to pay restitution, his death means that he is no longer has future earnings that will contribute to that restitution. Anytime a defendant who owes restitution passes away, our office runs a check to see if their estate has any assets that can be applied toward their restitution obligation. Our office performed that check on Mr. Torino's estate, but identified no such assets. On this slide here, we have the defendants who were not leaders but helped execute the conspiracy. The first 4 were nominees, the straw purchasers or sellers who were issued additional CMKM stock under false pretenses, sold that stock to the public, and returned the proceeds to the leaders. Each of these 4 were convicted and sentenced. The bottom 2 defendants helped the conspiracy logistically. Helen Bagley was alleged to be the transfer agent who issued the stock, but she passed away before she was convicted. Bryant Dvorak was an attorney who wrote opinion letters authorizing the stock transfers to these nominees. He entered into a pretrial diversion agreement, and after surrendering his law license and abiding by conditions of supervision, the charges against him were dismissed. This brings us to the last defendant, Nikolai Vysokovsky. Another common question my office receives is, why is the CMKM case still open? The answer is that we have 1 defendant left for which the charges have not been resolved, Mr. Vysokovsky. Now that is where the criminal case stands. So, what do you need to know about restitution? In an ideal world, the point of restitution is to put the victim back in the same position they were in before the criminal conduct occurred. Unfortunately, that rarely happens in practice. A 2018 report from the federal government studied data on restitution from 2014, 2015, and 2016 for criminal cases, and found that less than 3% of ordered restitution had been collected. So there's a big difference between getting restitution and getting on the court's restitution list. The U.S. Attorney's Office, where I work, does not decide who gets restitution or who gets on the restitution list. That decision is ultimately up to the court. Sometimes my office asks the court to include certain victims or certain expenses on a restitution list because we believe they belong, and the court disagrees because they conclude as a matter of law that this victim or that expense does not qualify. So my office's role is to identify victims, keep them informed about the criminal case, and to provide to the court the information it needs to decide whether a proposed victim qualifies for the restitution list. So as we discussed earlier, being a shareholder, not every CMKM shareholder is necessarily a victim who may seek restitution. Restitution is only authorized where a defendant's offense conduct causes an identifiable victim of the offense to suffer recoverable losses. That means we need to show the court 4 things for each victim: the defendant's offense caused the victim's losses. Here, the offense is the fraudulent press releases and the concealment of the additional shares. So as we talked about earlier, if a shareholder is claiming that they were harmed by naked short selling, even if they were right, that conduct is outside the scope of the offense. So they would not be eligible to seek restitution. Next, we have causation. The defendant's offense has to cause the victim's losses. So if a shareholder purchased CMKM stock before or after the fraudulent scheme, they would not be eligible to seek restitution because their losses would not have been caused by the defendant's conduct. The last element I want to discuss is the loss amount. As I mentioned earlier, restitution tries to put victims back in the position they were in before the criminal conduct occurred. So at most, a victim can seek their out-of-pocket losses. Victims cannot seek expected gains. So I have an example to illustrate this principle here. Victim invests $12 in defendant's company based on false representations that defendant will double that money in 1 year by paying out $2 monthly for 12 months. After just 2 months, defendant's fraud collapses. The victim invested $12. Victim was promised $2 a month for 12 months, so that's $24. The victim received $2 a month for the first 2 months before the scheme collapses, so that's $4. The restitution is $8, not $20. So this brings me to another common question my office receives. I have heard that I'm entitled to $1 per share of stock. Is that true? And the answer is that the most restitution you can seek is what you paid for the shares. So unless you paid $1 per share, you cannot seek $1 per share in restitution. I have a set of hypothetical examples to further illustrate this point. A person who purchased 10 shares of CMKM stock for $1 would be entitled to restitution in the amount of $1. A person who purchased 500 shares of CMKM stock for $1 would also be entitled to restitution in the amount of $1. So it doesn't matter how many shares you bought, the most you can seek is what you paid. To further emphasize this point, here's one more example. A person who received 50 or even 500 million shares of CMKM stock as a gift would not be entitled to restitution. Even though the person with 500 million shares owns 1 million times more stock than the person who owns 500 shares, they suffered no out-of-pocket losses, so they cannot seek restitution. In order to go to the court with a proposed restitution list, my office needs to know certain things that can allow us to provide the 4 elements of restitution. So here we need to know, when did the victim purchase the shares? That is to make sure the purchase is within the relevant time period during which the fraud was committed. How much did the victim pay in total for the shares? This is the loss amount from the purchase. Did the victim sell off any shares, and if so, for how much? Any sold shares offset the loss amount because, again, we're looking at out-of-pocket losses. So here's an example. In January 2004, victim purchases $10 of CMKM shares. The victim later sold some of those shares for $3. Victim may seek restitution of $7. So notice what's not in here, the volume of shares. What is key is how much the victim paid, not the volume of shares received. Now that we've discussed some of the legal concepts behind restitution, let's move to practically speaking what to expect next. We have received well over 1,000 restitution requests, most with supporting documentation. We are vetting those to see which ones have all the information we need that I talked about a few slides ago. By the end of March 2021, so this month, if you sent us a restitution request, my office will get back to you to let you know one of three things. Number one, based on what you provided, we will include you on the proposed list for the court. Number two, based on what you provided, we will not include you on the proposed list. Number three, we need more information, and this is specifically what we need from you. Once we have a final list of verified victims, my office will file a motion with the court asking it to include these victims in its restitution order. So after the court makes a decision and there's a restitution list, what can victims expect to receive and when? Please recall that I mentioned earlier that the vast majority of restitution is never collected. If a criminal defendant harms someone but can't afford to make the victim whole, there is no entity that steps in and compensates the victim on the defendant's behalf. Instead, it's up to the defendants to pay the victims back through restitution. And there are two primary ways restitution is collected. Number one, assets that are seized prior to or contemporaneous with the criminal charges. The seizure of assets is a fairly unusual occurrence. For the most part, frauds are often detected after the defendants have spent or transferred away all the money. In this particular case, the DOJ has not seized any assets related to this investigation. A common question my office receives is whether there are trust accounts holding millions of dollars for CMKM shareholders. And we have seen no evidence that such a trust exists, and have certainly have not seized any trusts because no assets were seized as part of this case. So that leaves us with the second main way restitution is collected: payments by defendants after sentencing. And that only applies to defendants who have been convicted. Here, the only defendants ordered to pay restitution who remain alive are role players. Which brings me to two more common questions that our office receives. When can I expect payment and how much? When to expect payment is tough to predict. We expect to provide the court with a proposed restitution list by the end of April. Then the timing is in the court's hand, or for the court's hands. But even once there is a restitution list, the court has a practice of waiting to release restitution payments until each victim can receive at least $25. Assuming that there are 1,000 victims in this case, and I expect that that's probably a close assumption, the current amount of restitution collected does not meet the $25 per person threshold, and it may never hit that threshold. That is something I can't predict at this point. We will ask the court to release the funds once the restitution list is approved, but we can't guarantee that will happen. So at this point, I have addressed many of the major questions my office has received, so I'm going to recap them briefly. Are only CMKM stockholders potential victims in this case? The answer is no. People who purchase stock in the other entities in the indictment may also be victims. Does this case involve naked short selling? And the answer to that is no. There are no allegations that any of the defendants engaged in naked short selling. Why is this case still open? That's because there's still a defendant at large who has not been arrested. How much will I receive per share? And the answer there is complicated, but the court may order restitution up to the price you paid, offset by any gains that you made from selling shares. But I want to emphasize that being ordered restitution is very different from receiving restitution. There are no seized assets in this case from which to draw funds for restitution. So if the court were to disperse funds tomorrow, each victim would receive less than $25. I suspect that this very limited amount of available restitution is not what many of you are hoping to hear. But unfortunately, the reality of these types of cases is that by the time the fraud is discovered and charged, the money is gone. A few other questions I wanted to address before ending the town hall are on this slide. How do I know I'm a registered victim? You will know that you're a registered victim because you will have received an email from Victim Notification Service, the VNS. And for many of the people who have reached out and submitted restitution requests, by the end of this month, we should be able to confirm whether or not our commitment to you is to confirm that we will identify whether you are a victim or not by the end of this month. The other option is we may need more information, but we'll get back to you by the end of this month. Another common question, if a victim accepts restitution, do they forfeit the ability to pursue other options? And the answer there is a little complicated. The answer is not necessarily. If you receive restitution, you can still pursue potentially other options. However, if you pursue other options, that may offset the restitution you're allowed to receive. So for example, if you lost $10,000 that you spent on CMKM shares and you were to receive $10,000 in compensation from a civil lawsuit, then that $10,000 would offset any restitution you would be owed from the criminal case.
Can we take one moment, Tony, to change interpreters? I apologize, sir.
No problem.
Go right ahead.
Thank you, Clay. And the last question I wanted to answer is there a difference between restitution and fines? And technically, in criminal cases, there is a difference. Restitution is intended to compensate victims for their losses, while fines are intended to punish defendants and deter them from continuing to criminal conduct in the future. So now what comes next? My office will make sure that we get back to everyone who submitted a restitution request by the end of this month. We expect to file a motion with the court proposing a restitution list by the end of April. And we will also have another town hall at the end of April to update everyone on the progress in this case. If you have any questions for that town hall, please submit them to usanv.cmkm@usdoj.gov. So that concludes our update for today. Please stay safe out there, and we'll be back at the end of April to give you another update on our progress. Thank you.